Hello, welcome to the Sandwich Crunch, and thank you for joining us where we navigate the trends and issues facing boomers and seniors in the workplace, home, and the community. And today my guest once again is my dad, Richard Brockett, and I'm very excited to have him back. We are following a series on estate planning, and in our series what we are going to talk about today in extensive detail is the healthcare directive. And we will actually have notes to share with you because we want to be sure that you hear the actual valid information that is provided by the American Bar Association Commission on Aging and Law. And the information that we are providing you is extremely important. It clarifies myths and it brings up the facts about what a healthcare directive is. So we welcome my dad.
Excuse me. Thanks, Bonnie. This is going to be interesting to talk about. I brought my own healthcare directive, which was generated, I believe it was in 2007. And in our conversation already today, I've found that the laws have changed very slightly, only on the witnessing of the document. Not the basic document, but just how you have to have it witnessed.
Well, on that note, what we're going to do is get you as our audience in a place so that you understand some of the basic terminology that we will be using. And I will read you the actual ABA, which is American Bar Association terms, so that you are clear on what we are talking about as we discuss the myths, the facts, and then as we graduate into the 5 wishes. The first thing is we are talking about a healthcare advance directive. And it is a generic term, and it is used for any document that gives instructions about your health care, and it appoints someone that helps make a medical treatment decision for you if you cannot make it for yourself. Living wills, durable powers of attorney health care are both types of healthcare advance directives. Another term is a living will. It is a document in which your state you state what you wish about life-sustaining medical treatment if you are terminally ill, permanently unconscious, or at the end of life or fatal illness. A durable power of attorney is a document in which you appoint someone else to make medical treatment decisions for you if you cannot make them for yourself. And the person is often referred to as an agent, a proxy, representative, or surrogate. And you can also include decision-making issues in this process. So these are the 3 terms that we will be referring to: the healthcare directive, a living will, and the durable power of attorney healthcare directive. And one additional place that we are going to be moving on to first is we're going to talk about myths and facts about healthcare directives. Because if you talk to a lot of people, they feel like the only time you need it is when you're going to die or you're older. Well, that is not the truth. So we're going to start off with quite a few of these myths and facts. Actually, we have 10 of them. And we will share with you not only factual stories that we are aware of, but also some personal experiences. So I will start with my dad. He's going to kick it off with one of the myths. I know, Dad, you get this. We're going to start you off.
Okay. There's a list of 10 myths that Bonnie pulled off of, I believe it was the website.
Of the American Bar Association,
right.
Commission on Law and
Okay, if you find yourself nodding yes to one of these myths, then you probably don't have an advanced healthcare directive because you have fallen for a myth. And let us try to expose a couple of these. One is you have to use your state's statutory form for your advanced directive to be valid. That's the myth. The reality is most states do not require a particular form, but do require witnessing or other specific signing formalities. That's a key requirement. Even if your state requires a specific form, doctors still have a legal obligation to respect your treatment wishes, regardless of the form you use. Most official state forms are either worded too generally or include multiple choice options that may be too broad to guide decisions about the particular medical situation you may find yourself in near the end of life. The critical task is to clarify your values, beliefs, and particular wishes that you want others to follow if they make decisions for you.
So as you can see, we're already starting off with our first myth of 10 that we will be talking about, that these are very elaborate facts that need to be clarified for you as our listener, and also to give you an understanding why it is so important to have a health care directive. It is important for you and your family. It is important for you because these are life-changing decisions that can happen to you in a matter of moments. You could walk across the street and be hit by a car. You could be a 16-year-old in a car accident and be left unconscious. You could be on a cruise and get one of those nasty viruses and come home with a very horrible sickness. There are so many things that can happen, so it doesn't just apply to when you get old. This is something that applies to every single age group. So I'm going to read you the next myth. You must have a living will to stop treatment near the end of death. Well, the fact is, treatment can be stopped without a living will, if everyone involved agrees. However, some kind of advance directive decisions may be more difficult and disputes are much more likely. And a durable power of attorney for healthcare is more useful and versatile advance directive because it applies to your healthcare decisions and empowers the person you name to make decisions for you if you become incapacitated. And if you are not aware, over 2/3 of our nation do not have a health care directive. Now, I think that's a very sad state of affairs for our country because that means there are a lot more medical expenses that are created. There are a lot of issues that happen because we do not have enough of us with health care directives. So we are going to now move on to our next myth.
Okay, this is titled myth number 4. An advance directive means, quote, do not treat. The fact is, an advance directive, or this advanced healthcare directive we're talking about, can express both what you want and don't want. Never assume it simply means do not treat. Even if you do not want treatment to cure you, you should always be kept reasonably pain-free and comfortable.
That is very true because you don't want to be in pain if you have a horrible illness. All right. Advance directives are legally binding, so doctors have to follow them. The fact is that directive laws merely give doctors and others immunity if they follow your valid advance directive. Doctors can always refuse to comply with your wishes if they have an objection of conscience or consider your wishes medically inappropriate. However, they may have an obligation to transfer you to another healthcare provider who will honor your wishes. The only reliable way is to discuss these values and wishes with your practitioner, with your doctors, so that they are aware of what you want, what your wishes are for end-of-life treatment, for situations if you have terminal illness and require certain types of treatment, for any type of medical treatment, so that you and your doctor are on the exact same page and are of the same conscious mind of state.
Okay, I'm just looking through and picking out one I like here. Advance directives are only for old people. That's a very big myth. It's true that more older rather than younger people use advance directives, but every adult should have one. Younger adults actually have more at stake because if stricken by serious disease or accident, medical technology may keep them alive but insentient for decades. Some of the most well-known right-to-die cases arose from the experiences of young people For example, Karen Ann Quinlan, Nancy Cruzan, incapacitated by tragic illnesses or car accidents and maintained on life support. Obviously, these two people did not have an advance directive, and it took years to finally settle their case.
Yes, actually, I believe it was the Ann Quinlan one, and please, I will validate that on my website, because you can visit my website for more information on estate planning at bonniekuhn.com. However, this issue is a very, very powerful issue. This young woman was in a car accident, and in this car accident, she was found by the side of the road by an innocent bystander who called the emergency services to come pick her up, which is the EMT. They are the ambulance people. They are the ones that come and pick you up and take you to the hospital. By law, they must do everything possible to resuscitate you. She had been on the side of the road, dead for close to 10 to 12 minutes. Now, the EMT team did resuscitate her, but she came back in a vegetative state. And they went through years and years of court battles to be able to take over the care of her life and be able to release her the way the family wanted to take care of her and give her the life that she would have chosen. And the reason why it went into court was because no one had a health care directive. She in particular did not have a health care directive, and her doctors were not aware of what her wishes would be. This was a very, very tragic case, and there are many others out there just like that. So let's go on to the next myth. And before I go on, and obviously we are reading these things to you, but the reason why is I can't imagine most of you wanting to sit out there on your computer and do some searching on estate planning. Like, gee whiz, I think I want to hang out on Facebook, or let's go look up some healthcare directive stuff. I think you'd probably want it on Facebook, or you'd want to be, checking out something, or write an email, send a friend a note, or do something like that. Most people do not want to be researching this information. And this is critical to your life. This is critical to your family's peace of mind. It's critical to your own peace of mind. I mean, can you imagine if you got into an accident and you were in a coma and you were brought to the emergency room and they could not resuscitate you, and you now have, say you have 2 or 3 children and you've got 2 or 3 grandchildren. Maybe you have your parents, maybe even had your great-grandparents, and now everybody is there fighting amongst themselves how to take care of you and what to do. What do they want? What would mom want? How would she want to be taken care of? So that is why these are so critical for you to understand. So in this myth, if I name a healthcare proxy, I give up the right to make my own decisions. Well, that is not true. Naming a healthcare proxy or agent does not take away any of your authority. You always have the right while you are still competent. And you can override any decisions of your proxy or revoke your proxy completely. But if you do not name a proxy or an agent, the likelihood of needing a court-appointed guardian grows greater, especially if there's a disagreement regarding your treatment amongst family and doctors. And now a court-appointed guardian may not be anyone you would want to represent you. And that is another thing to consider when putting together a healthcare directive, is that person who represents you, that proxy, say there's a son, a daughter, a grandson, a friend, or someone who you know you do not want to make medical decisions for you, and maybe they're the loudest spoken one in the court system, and they get the decision, how would you feel then if they were the ones to make the decisions for you because you didn't make the decisions on how you wanted to have your life taken care of? Dad?
Okay. Myth. I should wait until I am sure about what I want before signing an advance directive. That's obviously a myth. No, most of us have some fact ambivalence about what we want, and that's okay, because treatment near the end of life can be complicated. We can't predict all the facts and circumstances that may face us in the future, and treatment wishes may change. You can at least appoint your proxy if you have someone whom you can trust.
And that's back to what I just said, appointing a proxy for someone you trust. And it's not just one proxy. They always recommend a minimum of 2, if not 3, even 4, for many reasons. You may have one that you've listed who may be in the hospital themselves, or maybe something has happened to them, or they're in another country and cannot make decisions for you. You may have 2 people that are not able to make it because they are also out of the country or something has happened to them. So it is very, very important to have 2 minimum, preferably 3 to 4 proxies for your healthcare directive. And we have 3 more myths. So just talking to my doctor and family about what I want is legally effective. Well, meaningful discussion with your doctor and family is actually the most appropriate thing to do, and it is the most important step to do, but the question is it legally effective? The legally effective is misleading because even a legally effective document does not automatically carry out your wishes. The best strategy is to use good health decisions workbooks such as 5 Wishes Through Aging of Dignity to help you clarify your wishes. You talk with your physician, you talk with your healthcare agent, your family about your wishes, and you put your wishes in writing in an advanced healthcare directive. This is essential. It's not just you clarifying what you want, it's getting your whole team together so everyone knows what it is you wish and how you wish to be taken care of. Healthcare directives affect us in many ways. They affect us if we enter the hospital in an emergency situation. Maybe you are knocked out, say you fall out of a boat and you've gone water skiing, and you got knocked out for whatever reason, and you're in the hospital and you need to have somebody represent you. So a healthcare directive is an essential aspect of what you need in order to have, again, peace of mind. Dad.
Okay, here's my last myth. Once I give my doctor a signed copy of my directive, my task is done. Well, not quite. No, you've just started. First, make sure your doctor understands and supports your wishes. Second, there's no guarantee that your directive will follow you in your medical record, especially if you're transferred from one facility to another. You or your proxy should always double check to be sure your providers are aware of your directive and have a copy, which means dragging along 1 or 2 extra copies. Advanced planning is an ongoing process. Review your wishes yearly or any time your health or family status changes. Making an appropriate change and communicate these changes as needed.
You know, what's interesting about that, I was talking with some friends of ours and we were discussing estate planning and we were talking about a healthcare directive. And what was very interesting, I thought, wow, what a great idea. They made a copy of it and uploaded it onto their phone. So they automatically had a copy that they could email from their phone to the hospital, wherever they were at. And then it was on their phone, and they noted that it was on their phone, on the back of their phone, that you had access to their healthcare directive on their phone. And since most of us have a cell phone, what a great way to utilize that. I believe this is our last myth before we move on. If I am living at home and do not want to be resuscitated by an EMS team, if my heart or breath stops, my advance directive must say so. Well, not so. Your advance directive will usually not help in this situation. If someone dials 911, that is the emergency, that is your paramedic, they must come and resuscitate you. That is what I've explained before. By law, they must resuscitate you. However, you need a special form out-of-hospital form called a DNR, do not resuscitate. And this form is not the same as your healthcare directive. In most states, both the patient and doctor must sign this special form, and the patient then can wear either a bracelet or you can have it on your necklace. You also might want to have it in your phone so that they know that you do not want to be resuscitated. Now, on this form, there are different avenues of which you can pursue on different types of resuscitation. And for example, if you are an older person, such as before mom passed, mom had very severe osteoporosis, which meant it was impossible for them to do any kind of resuscitation because it would have immediately killed her. Now, there are different things that you can choose on a DNR form. You can change them, but they also do need to be updated on an annual basis, and your doctor must have a copy of it, and you must have a copy of it as well. And my recommendation is that you keep a copy of this, along with your healthcare directive, along with all your medications, in a plastic bag in your refrigerator, and you put a sticker on your refrigerator that says DNR medical information for such and such refrigerator, or put it on your medicine cabinet. Have something so when the emergency team comes in, they know where to look to know what you want and what you need. So now we're going to move on to a really wonderful program put on by Aging with Dignity, and it's called 5 Wishes. And this is one we alluded to in our first interview, and Dad is going to talk about it more because he was the one who brought me into this, and I thought Dad would be a perfect person to kick this off.
All right. One thing I'd like to discuss briefly before we get into that is a very broad overview of what a healthcare directive is. It's a 2-part document, and it's a revocable document, which means once you put it together, if you don't like it, you can tear it up and throw it away and nobody cares. It's your document. And it's in 2 parts. The first part of it is where you name your proxy or agent, whatever you want to call that person, and that's the person that you have given your permission to make medical decisions for you. Not financial decisions like paying your PG&E bill, but strictly medical decisions. The second part of the Advanced Healthcare Directive is where you get to state, this is what I want done to me in my final hours or days or years. Or, as Bonnie has said, if you're in a horrendous accident of some kind, this is how I want to be treated. And conversely, this is what I don't want done to me, which we've just talked about, the DNR. When my wife was being taken to the hospital numerous times, fortunately that never came up with the ambulance, but it did come up at the hospital. And we made a unanimous decision that because of her frail body, DNR or resuscitation would have been lethal. So we were there to make the decision. But let's say that we had not even been in town when all this took place. It's very conceivable that getting picked up from home, she would never have actually made it to the hospital. The resuscitation would have taken her life. Or when she got to the hospital, if they needed to do resuscitation, likewise, it could have been deadly. Fortunately, we were there and were able to take care of this. Even though we had a healthcare directive, that part covered the hospital. It did not cover, at the time we didn't even realize, it didn't cover the ambulance and the paramedics coming in. So the thing I wanted to bring up about this is it's a very simple document. You do not need an attorney to prepare this, as we'll discuss here in this 5 Wishes, which is nothing more than a booklet with to me it seems like a zillion questions of this is what I want to have done to me or for me, and this is who I want to assign or choose as my agent. And there are other booklets like this that you can get off the internet. Bonnie knows where they are. I had mine done by my attorney when we did our entire estate plan. But the key is, if you do this, even with one of these booklets, as we talked about in one of these myths, it's important that you get it properly witnessed, or it is not a valid document in California.
Correct.
Each state has its own requirements of what witnessing is.
Yes, and actually I do want to add to that, and we are going to be tightening up on time, so what we're going to do is address a few of the questions that are addressed in 5 Wishes, and in our series we will continue to address this as well as other aspects of estate planning. But within the 5 Wishes, there are 5 major questions that they ask. And the first question is, the person I want to make care decisions for me when I can't. That is a very important question for you to consider and to validate and to discuss. Don't just assign someone without having that discussion with them. The second is the kind of medical treatment you want or you don't want. That is very, very important. The third is how comfortable I want to be. The fourth is how I want people to treat me. How do you want to be treated? Do you want to be sent off to a nursing care home? Do you want to come home in hospice if you are in a terminal state? How do you want to be treated? And what I want my loved ones to know. So, Dad, what else can you add to that?
Well,
there's so much in here. This is a very powerful book.
I don't know. This is if you choose to use this 5 Wishes book or one of the other booklets that you can download, what it does is make sure you cover all the bases. And basically you go through and answer the questions that come up as Bonnie just went through the 5 Wishes. All you need to do is answer these questions. And even if you leave one out, it doesn't invalidate the document.
And that is so true, Dad. And we are going to be carrying on this conversation in our future presentations. And we want to thank you so much for sitting and joining us here on the Sandwich Crunch, where we navigate the trends and issues facing seniors and boomers at home, in the workplace, and the community.